Hello. Not prepared, but we're doing it anyway. Hello.
Hi,
Hi.
hi. How are you?
I'm good. How are you?
Hanging in there.
Thank you for jumping on with me real quick. I want to get your legal input. I'm going to pull this up real quick so we can talk about it. You
We
can
have
kind
an
of,
echo.
I do.
Is it you or me?
Um, maybe me. Is that better?
Yeah.
Okay. Perfect. All right. Let me get this pulled up. Um, It's a little bit sassy, their response.
It's as expected.
Yeah,
They went full zombie.
it's a very lally response.
Yeah, I mean, they're basically saying it should be barred on procedural grounds. You shouldn't even think about this, and have no concern about the fact that there are what seem to be credible allegations that there could be 12 out of 12 jurors who believe that they meant to acquit on 2 or 3 counts. And they're certainly entitled to oppose it. I mean, their response is not a bad one legally. I mean, they made all the proper arguments, but they just give short shrift to any real concerns about the fact that what if we retry someone that a jury meant to acquit? And they just don't care. I mean, they're going to get killed for this response, as you can imagine, publicly,
Yeah,
um, because they just are saying if the jury, they had an opportunity. Well, back up. They're blaming the defense for not raising anything, but they're kind of ignoring the fact that it's the jurors on their own who reached out of fear of a miscarriage of justice. And whether the law in Massachusetts permits this or not, sometimes the law gets extended for situations that are just not thought of. And case law only relates to what's happened in the past. Sometimes there are new developments in the law and new things happen. This is
yeah,
pretty new. I mean, I've never heard of a situation where within days jurors come out of the woodwork calling the lawyers and saying this is wrong, this is wrong. And the DA is completely ignoring the fact that the substance of the defense motion is that the jury was confused and didn't know what was going on or how to deal with it. And the DA's response just totally wants to say, well, why didn't the defense jump up and say, we oppose a mistrial? So
right.
just again,
But
they can make that argument, but I think it just doesn't look good.
see, don't you think from because you tell me because you're the attorney. If my thoughts on it are if they're saying that they're deadlocked, I would assume that they're deadlocked on all of them. That's what we all assumed.
Mhm.
So when they're saying that the defense should have said, oh no, 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 you need to check and make sure that, to me that sounds a little bit uh, unreasonable, unrealistic.
Yeah, they're basically saying that what should have happened is in every single case that a jury says they're deadlocked, that the defense ought to jump up and say, well, are you sure? Are there these counts? Or the prosecution for that matter. I mean, there could be certain cases where the concern is that they could have had a verdict that goes the other way on one count. It could be a guilty as opposed to an acquittal. Um, but to me, what makes this more interesting is that the jury is coming forward on their own, four of them in some capacity, indicating that all 12 of them agree and saying we didn't understand what was going on. Also, there are other factual questions which theoretically could relate to this. The judge had that conversation with the jurors right after. That may be nothing, but everybody seems to be ignoring that. And for the DA to just take a position that we're prepared to retry her potentially for murder, and they could care less that the jury, excuse me, may have been confused and actually acquitted her of that count, to not even express any concern about that is just unjust. Whatever, you can still challenge the motion, but there just seems to be a delicate way to do it. And,
Yeah.
that's not them. They're bulls in a china shop. They only know one speed. And that's just a complete lack of self-awareness, particularly in a case like this, where they've been accused of misreading the room, on
Yeah.
issue after issue. And this just appears to be another example of that.
Yeah. I think you and I, on one of the panels that we did before, talked about that, how they seem much more concerned about a conviction as opposed to like carrying out justice the way that you're supposed to, which is really, it's really concerning for it being from prosecution, because you expect, defense lawyers to tightrope walk, through certain issues and stuff like that. Like, you expect that. But the Commonwealth, and not that the prosecution does it too, but for them to be so just, I mean, even like I've been working on this podcast episode, and like I got some hate mail this morning because they said that the last 3 episodes I've been so hard on Lally because I'm pointing out all of his lies, and I'm like, he's a prosecutor, like he's,
Hey, it is what it is. I mean,
yeah,
look, they could have even submitted a response that said, we recognize the seriousness of this. And they could have even fashioned a response that said something along the lines of, we don't oppose taking evidence from jurors to determine what is going on here, with the express condition, from the court, that we're not waiving our procedural defenses. That, in other words,
right,
we don't want to waive the argument that the defense should have objected, but out of an abundance of caution, and given the public interest, and given the allegations that are being made, that we don't oppose at least allowing the jurors to be communicated with to potentially testify. And, the case law that they rely on, I mean, there was some discussion about this the other day. It's a little bit distinguished, the Supreme Court case, Bluford versus Arkansas.
mm-hmm,
In that case, the jury initially said, they were polled and said that we want to acquit on murder, but we don't have a decision on other charges. And the judge said, well, if you don't have a decision on the other charges, we're going to go back to deliberating. And then later on, when, there was a hung jury and the defendant argued, well, the defendant was acquitted on murder because they told the judge that, the rationale for the Supreme Court in that case was, well, that's not true, because although they initially said that they wanted to vote an acquittal, they went back and deliberated again. And you don't know that there could have been one juror or 12 or somewhere in
right,
between that might have changed their mind. That is entirely different than what happened here, as per the affidavits of Jackson and Yannetti, which are saying that the jurors have contacted us and said, we absolutely finished at the time that we sent the last note, acquitted on 2 counts. And before we knew anything, the judge just said, mistrial, you're done. They did not go back to deliberate further. They did not go back and alter potentially, any one of them, what their decision was. So I don't
yeah,
think Bluford is directly on point, because that's kind of a big difference.
gotcha. The part about, let's see, I read through it so fast. The Where they said that the attorneys are only allowed to talk to jurors about the 3 things.
Right.
Hold on, let me find it.
Right. One
So
of
they were
which is
saying that,
not operations. Right.
yeah. Tell me what you think on that. I know that Massachusetts law is different than a lot of laws that I've seen on different.
I mean, where I come from, I mean, there's no prohibition of talking to jurors. It may not carry weight if you reach out to a jury and say, this is what they told me, but you can do it. But the point here is, this is a unique situation. And although under Massachusetts law, an attorney is not supposed to discuss the deliberative process with jurors and reach out to them for that purpose, this is one of those situations I was talking about earlier that may require some new ground. I mean, the law is a living, breathing concept, and there are times where there are new scenarios not envisioned by past case law that require changes in the law. It happens all the time. Not that commonly, but it happens. And to say that you're not allowed to discuss the deliberative process with jurors when 4 jurors or representatives of jurors come forward within a day or two of the deliberations and contact them and say, no, 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 we acquitted. And, in fact, all 12 of us would tell you that. Um,
Yeah.
if your response is, well, you're not allowed to talk about that, once
Right.
again, that is a complete lack of self-awareness. That may be the current state of the law, but what prosecutor who is a minister of justice, who wears the white hat, is concerned about, fair prosecution, is not at least concerned. You don't have to agree with the defense, but how do
Right.
you not even consider and express some degree of concern that you may be attempting to retry an acquitted defendant on a case that could result in her going to prison for the rest of her natural life, which would
Right.
be the most un-American concept imaginable. And they don't even address that. They don't express any concern with that. Their response is that you lawyers are too dumb and you should have stood up and you should have said, we don't agree to this, and you didn't. So, there's nothing to see here. What's for dinner? And let's tee it up for a retrial. And oh, by the way, if we want to try her for murder, we will.
Yeah.
They're just so tone deaf in
Yeah.
how they deal with it. But it's exactly what I thought they would do. I mean, these people have no shame.
Right. And see, that was one of the things too, because if that was one of the questions that I had, because as an attorney, if this is the law that you're not supposed to talk to them about these things, even if they reach out to you, what else do you expect? And so I'm glad to hear you say, like that is one of the things. It's like, law is a living, breathing thing. It's constantly moving.
If a juror calls me and says, notwithstanding what the Massachusetts precedent is, and says, I have to tell you, my conscience is killing me, I feel compelled to reach out to you because we acquitted her of murder. Okay.
Mm-hmm.
And this is no joke. And oh my God, we don't know what happened. If you think for a second, my response is going to be, excuse me, sir or ma'am, I'm going to hang up the phone because you're representing a client who could potentially get retried for a crime for which she was acquitted.
Yeah.
You're going to listen to that. And, they're very subtle in doing this, but they're implying that Jackson and Yannetti did something unethical. If you read this carefully, there are these implications that they're talking about, subject matter they're not permitted. And what I would expect they're going to do is argue that this is a unique situation, that this is beyond just double jeopardy in the classic sense. This is fundamental due process. I mean, you can't ignore what's happening here. And what is the harm in the judge saying, I'm going to let you make all the arguments you want to make, and I will reserve judgment on whether the defense should have objected. But on the other hand, as the judge, I'm concerned that the jurors could be coming forward and saying, we didn't understand your instructions. Okay.
Mm-hmm.
We didn't understand what we were supposed to do. We really meant this. And again, she may rule, or another judge, if she's a witness, may rule any way they want. But in a case like this, that already the public has such little confidence in, because this has been just a complete fiasco for so many different reasons. If the answer here is to say, never mind the man behind the curtain, there's nothing to see here, who cares that the 12 jurors basically all believe she was acquitted? This is so short-sighted by the DA because they're just going to get killed publicly. They're going to look like the brutes and zombies that everybody already thinks they are. And the irony is, aren't they going to dismiss the murder count anyway if they retry this? I mean, even these people. Another thing they could have done was say, Judge, let me make this easy for you. We're not even going to retry her for murder. So, now they still have to deal with it on the third count, I suppose. But, a totally separate issue is the murder charge is just stupid and a waste of time. And, it hurts their credibility by even trying that. But they only know one speed. And their attitude is simply, this is nonsense. And we don't care that she may have been acquitted. We just don't care. And any sane prosecutor would at least address that concern in some way, not Michael Morrissey.
Yeah. That's the thing. It's like the whole thing is like, nope, you had your chance. Like, can't do this. And it really is. It seemed so just tone deaf, I
Well, you
think
know
is
what they're
the,
trying to do, I believe too? They're trying to foment dissent amongst the defense team. And they're almost double dog daring Karen Reed, if she were ultimately to get convicted, to accuse these lawyers, who are A+ lawyers, by the way, of some form of ineffective assistance of counsel by failing to object. And was that ineffective by doing that? And did that somehow cost her? And they love that. The prosecution would love to create, and that's not going to happen. Okay. There is no way that that's going to create any dissension among these people, whether they should have objected or not. Why would any defense attorney in these circumstances have any reason to believe that when they said, the judge just said, I'm ordering a mistrial if they don't come to a verdict? Could they have said something? Yeah, they could have. The judge could have too, whether she's legally obligated to or not.
mhm.
Um, but at what point are you going substance over form, or are you going to choose form over substance? I mean,
Yeah.
given what why not at a minimum issue an order allowing the taking of evidence? Let's see if they get affidavits. Maybe this is a nothing burger. Maybe some of the jurors say, you know what, those jurors are not actually correct. And that's the end of it. That would be the end of it.
Yeah.
Um, why not hear from, the most interesting juror would be the foreperson. Why didn't you check the box? I don't know. Maybe he has a really good explanation. Maybe he was confused. Maybe he told them we don't have to, and they relied on that.
Yeah.
What was said to the judge in that meeting? Were some of them freaking out and saying we have a concern? And is the judge a witness? There's so much going on here, and you
So
really.
how would that part work? Because if the judge does become a witness, then this would go to another judge to be heard.
Well,
Right. So
yeah, I
could
would
you?
be if I were them. I would be very strongly in a very aggressive response to this. In addition to saying all the things that I'm saying now about how tone deaf and how little regard for constitutional rights they have in light of all this, but I would push back and say we need evidence. We need to know what happened. And by the way, Your Honor, you're part of that process, and we reserve the right to seek assignment to another judge because you're a material witness.
Right.
And
I
then,
think with her, even when we're trying to do the recusal and everything, I think it's going to be a hard push for that to happen. I mean, what would be the next process? I know we have the status hearing on the 22nd. Um,
well, this being Chinatown or Canton and Dedham, what's probably going to happen is the judge is, well, let's wait. Does the defense file a surreply to this? My guess is yes, because that's what real lawyers do, that they file a response to the response, basically. Um, Probably within a matter of days, I would imagine. I would
yeah.
also think that if they have other jurors that have come forward, the time to light that up is right now. I mean, and push it back to how outrageous this may very well be. But assuming all that, what probably would happen on July 22nd is the judge will say, I've considered the papers of both sides, and I am not ordering any release of information to speak to the jurors. I'm not taking affidavits. I'm not granting a hearing. I am denying this. I find that the defense attorneys waived their right to this, and that the jury was clear in what they said. And, look, one of the things the DA wrote was that the language used by the jury was that we are divided as to the charges, plural. I mean, that's a fair point for them. I mean, um, fair is fair. That's they didn't say one of the charges bothers us. Now they may not again have been thinking,
But
yeah,
but it's on the second count, and there are lessers in that. So I
that's
think that
true.
that can be interpreted
Absolutely. It
as
can.
that.
You can. I agree with you. What I'm saying is, for the way they phrase it, it's
Hmm.
not a silly argument.
Right.
But I would expect that the way it works in this court is that she denies it. and says, when are we retrying the case?
Yeah. Yeah.
Um, I don't think that's the right thing to do for a lot of reasons. And I think, once again, the DA is so tone deaf, lacks so much self-awareness, that if they think that there's pressure on them now not to retry this case, it's going to be much, much worse. And I also think this is just how short-sighted they are. We're being led to believe that there are 12 jurors who say that Karen Reed got screwed. And that doesn't mean they think she's actually innocent either. Some of them were
Right.
fully prepared to find her guilty of manslaughter, which is, we don't understand that, but whatever. That's the time. That's what they wanted to do. What do you think is going to happen when a big news story comes out around July 22nd and the judge says, I don't even want to hear it? Okay. If you don't think that some of those jurors are not going to say, F this, I'm calling reporters, I'm calling people like you, and I'm happy to talk exactly what happened. Because at this point, there's no reason not to for them.
Yeah.
And if the court is not even interested in hearing from them to explain that we believe that we did something, we have to live with this for the rest of our lives. What if she gets convicted of murder at a retrial? Now, that's never going to happen. But what if she did, and you're one of these 12 jurors who actually acquitted her?
Yeah.
That's going to eat you alive to the end. I mean, that's going to kill you emotionally.
Yeah.
So I would think, and again, they're just too dumb and short-sighted to see the big picture, that when the judge denies this on the papers, I think jurors are going to come out of the woodwork. I think they're going to talk. I think they're going to lay it all out, and they're going to say, I'm outraged that no one would even take us seriously. And, it's offensive that the DA that looks at us as just, nobodies in this process. Maybe will the feds talk to the jurors? I don't know. I don't think that they will on their own go talk. I mean, that's really getting deep into this kind of thing. But if the jurors think there's corruption and they start doing stuff like that, nothing stops them from making phone calls. But I don't think whatever the feds are doing, that they're going to assume that anything happened here, unless there are jurors who talk and say, but we told her we had a verdict. Now, I'm not suggesting that's the case. That would be stunning beyond belief if one of the jurors were to come forward and say, we told her after court we had a verdict, and she just said, go home.
Yeah.
That would be a scandal. That would be like epic scandal. That's not likely. In all fairness, almost certainly what the judge did after the non-verdict, as we call it, would be to say, oh my God, thank you for your time. I know this was difficult, 2 months. Take home the donuts. Thank you for your service and good luck. And, we're here for you if you want to, whatever, that kind of thing. But on the other hand, were there jurors in that meeting who are looking at each other and then like nodding their head? Do we tell the judge? I mean, wouldn't you want to hear that evidence? And it doesn't mean that the defense is correct, that there were verdicts in a legal sense, but it's just remarkable that the DA's position is, who cares? This is all nonsense. They should have objected, and we don't care, even if it's true. We're not even going to address it. They don't even address it. They literally have zero concern about what's going on with the jurors and whether they got schnookered. Their only point was, you shouldn't have been talking to the jury about it anyway.
Yeah.
And that is completely, as a prosecutor, somebody who's supposed to seek justice, just ass backwards.
Yeah. And I think that if I were reading that, and especially because in that one affidavit, they're talking about how like they felt uncomfortable, and, and I would be the same way though. If I'm reading it, I'm like, oh, so, you don't care about, what we think or what we agreed on or what actually happened. I think that I'd be pissed if I was a juror, and
It's, again, I really think the politically correct way for a prosecutor to do this, which is clearly not these people, would say, we cautiously do not oppose gathering evidence. These are very serious allegations. We are confident that this does not have legal merit, but in the interest of fairness, transparency, and possible justice to Karen Reed, we're not opposed to letting this flesh itself out, as long as Your Honor allows us to argue that they waive their right. But that's just not in these people's DNA. I mean, they are just so emotionally invested in this, and they only know one speed. And that's why, let's be candid, nobody takes the Norfolk DA's office seriously outside of themselves.
No, not at all.
No,
Nobody.
I mean they're a national embarrassment to the profession of
Yeah.
prosecuting.
Yeah. The part, and I know you are limited on time, but I'm trying to get all my
Yeah, no, no, go
questions
ahead.
in for you. The part where he said that it would be improper for the court to inquire through affidavits or evidentiary hearing the substance of the jury's deliberations. So with that part, because I know that
What page is that? I have it right here. What page is it?
12.
Okay. Yeah.
Um, the
Uh,
improper for the court to inquire through affidavits or an evidentiary hearing. Can you talk about that a little bit? Like, what would so if, I don't think Bev's going to go for this personally, but if she did, or if this happened, what would be the most likely process for
if
going?
everybody was acting in a way that you would hope lawyers, judges, and everyone concerned about a possible, I said possible, not a miscarriage of justice, possible miscarriage of justice, it's very simple. The defense has made very serious, admittedly hearsay allegations of really troubling facts. Okay.
Yeah.
By doing that, they have opened the door to, I believe, further inquiry. Okay. It's not sufficient. Clearly, it is all hearsay. But the next logical thing would be the judge to issue an order allowing them to try to speak to jurors or bring jurors in straight into court, and just even if the court were to ask them what's going on, or allow the defense to get affidavits, allow the prosecutor to get affidavits, and determine, do the hearsay allegations submitted by the defense have any merit? And if it turns out that 12 out of 12 jurors say absolutely yes, then the next logical thing for the judge to do would say, we need to have a hearing. We need to have, and nobody wants jurors to testify. That's
Right.
nobody ever wants that. On the other hand, that is a secondary concern to an acquitted murder defendant being retried for murder. That
Right.
kind of trumps the juror's right to not be bothered, if you will. And
Yeah.
what she could do is bring him in, kill the live stream, no names, no whatever, no cameras, do what she did when like kids testified at the trial. So, they get that they're entitled, I think, to some degree of secrecy, um, and do a hearing, make findings of fact, let the parties argue what the legal issues are, and issue a written decision, but do it after a hearing when you have a full explanation of what happened. If she denies this on the papers, which she's probably going to do, and you never know what really happened, all you're doing is creating more suspicion, more skepticism, more concern that this is Chinatown, not, a normal jurisdiction on fair being fair. And when given the opportunity in this county, they always seem to do it the wrong way.
Yeah. Yeah. So, oh gosh. And what about somebody had asked, I didn't get to show it. It went by a little while ago. Somebody asked, how would this work on appellate issues, or because there were other but I mean, if it's retried, then there would be no appeals for this, right? Everything would be,
This is
or
tricky. So, they're right now, they haven't been able to generate a record. In order to appeal, you need a record on appeal.
right.
And right now, all you have are these affirmations of Jackson and Yannetti. So probably this would not be part, at least not in New York. I don't want to speak for how they do this in Massachusetts, but in New York, this would be filed in what's called a post-conviction motion in the trial court, where eventually you would submit as much evidence as you have, demanding a hearing based on this. And ultimately, what the judge either agrees to do or not do now would be raised by them later anyway. So it's
Yeah.
really just kicking the can down the road. They're not going to let this go.
Right. Yeah. Oh gosh, it'll be interesting. I every time I think that I'm gonna get a day off and something's, gonna calm down. And I did hear somebody said too in the comments. I did see people were sending me this all day too, that they said that the foreman had I guess somebody had talked to the foreman and that he said that he confirmed the whole 12 thing. And again, this is people sending this to me. I have not vetted anything, just pure. This
I
is what
saw
people have been
that
sending me.
there was something online. I think it was Turtle Boy who spoke to or knows who the juror is. And I think what he said was that the foreman, who was one of the guilty votes on manslaughter, which at least gives him more credibility for this purpose, was confirming the 12 out of 12 acquittal. And I think the other thing that he reported was that he was troubled by the testimony about the embedded glass in John O'Keefe's shirt, which I'm not sure, A, that was entirely accurate, and B,
Right.
given that it was in with Proctor and Buchanan and unaccounted for a period of time, I'm not sure why that would be so powerful. But
Yeah.
you know,
But also, that wasn't even testified to by somebody who saw it. It was just said by Lally. The only
right,
thing that was testified to about those microscopic pieces were the person who got them said that she got them. They were in a bag.
right.
When
This
she.
You're right. And this goes to the whole problem with not having read back in Massachusetts and in a trial with 70 witnesses. And there's, what if this four-person who, by all accounts was a retired cop and current PA. So this is clearly an intelligent person. This is not some dope who's just not paying attention, but he may very well have misheard or mistook the evidence and cited non-evidence because Lally was, being Lally,
Mhm.
and hung up a jury, or at least one vote hanging up a jury. And also, as a retired cop, when he starts talking about this, does he have an outsized voice? Probably. Given that he's a former cop and this is a police case, and he's also a PA, so he's got medical training, which was big in this case. So I would assume
Mhm.
that he had a lot of influence amongst the jurors for whatever his opinions were.
Yeah. Yeah. And it's interesting that he was the one picked by the judge, and for that, I don't know how Massachusetts law works though, so I can't say if
I
it's
don't know, other than I do know that he was juror number one, which
okay.
makes me feel less skeptical because that's the most obvious, like, sorry, somebody has to be it. And you're staring at me from seat one. And I mean, for example, in New York, juror one is by default the four-person. Like, there's no, that's just the way it is. If you're the unhappy person that gets picked to be juror number one, you get the job. That's just the
Yeah.
way, and that's purely by where they seat you when they call your names randomly in the beginning. So I don't read into that too much,
Yeah.
at least on
Well,
that issue. There's a lot of other things perhaps to read into, but not that.
yeah. Oh, there's plenty.
Yeah, yeah. This is not normal. There's nothing normal about this case. For people who watch trials, this is not normal by any stretch. Everything about this case is just terrible in terms of how the system works.
Yeah. So what do you expect?
I expect the defense probably is going to produce more affidavits or lawyer affirmations prior to July 22nd to turn the heat up and win the public over even more. I would expect that they're going to file a response to this, criticizing their kind of aloof response to the fundamental issue of fairness to the accused, um, as well as I assume they're going to have to push back on whether they waive the issue or not. And then I think ultimately the judge will say, upon consideration of all of this, I'm not doing anything, and I'm not allowing you to develop further evidence. I'm not ordering a hearing. I'm not doing anything other than finding that there was a hung jury, and she will look at Yannetti and say, you specifically said you wanted the mistrial, and get a few digs in there, and then
Yeah.
we'll say, when are we retrying the case? And then the pressure will go back to the DA about if they're really retrying the case, which they'll say they are. They'll drop it at the end, not now. But are they even going to still prosecute the murder case, which to me would be the easy way out of this issue. If they just said, look, forget the murder charge, they don't even have to address 90% of this nonsense.
I agree, and I think that would be, then you don't have to go through the stuff with the jurors and stuff, because I mean, look, based on what we saw, I don't know anybody other than the people who are emotionally invested in it and have acted like assholes, so now they have to stick with it. I don't know anybody who thinks that that they would have agreed to the second degree murder thing. Like nobody that's actually basing it on anything that was provided. The only people who do are the ones who are like the pitchfork toting,
right,
weirdos. So dropping that one would make the most sense for Lally, number one, especially because he's trying this all by himself. Think about all the time he could have saved, and if we didn't have to hear about Aruba and text messages and that kind of stuff.
I mean, yeah, you're probably lopping off at least a couple days. You're probably lopping off 10 witnesses or something like that, and it also makes you think differently and streamline the case. And if they're going to retry it, you would think that they are going to streamline the case. And what's interesting is that the defense did the exact opposite. They kind of read the room and realized that because he was over trying it, they really cut their case down. Whereas if there is a retrial, I think that there's a lot more things that they would be inclined to do that they kind of chose not to do the first time. If there is a retrial, which I still don't think there will be, but I mean, there could be.
Yeah. If there is, I just can't see them doing the murder charge again.
No,
I really can't.
It's crazy. And the idea that, something happened in Aruba a few weeks earlier, which somehow, even though we were arguing that day and then we were all lovey-dovey at the bar, that I decided, by the way, at a house where I dropped, people knew I was dropping you off. I knew they were there. And I'm just going to intentionally mow you down in front of all those windows, in front of everyone across the street. And just, I mean, it makes no sense. I mean, the only thing that I think even would pass the laugh test is, which I don't even believe, by the way, is some sort of accident and then just leaving and then later on saying, oh shit, did I do something here? Which I don't, in light of all the other evidence, and I know we've beaten this to death many times with the Arcus stuff and all the other stuff, that doesn't work anyway. I don't think.
Right. Melissa Filson said, will there be a hearing before the 22nd to argue this motion? You said the defense will probably do their response.
I think they will. But again, the judge appears to be doing nothing. I mean, she seems to be just letting this all happen. I would have thought she would have issued a scheduling order by now, even called them in, published some kind of order saying, if your responses do this, any other responses do this, and either we'll deal with this on the 22nd or we're going to have a virtual appearance before then. And, you're not hearing any of that. It just seems like she's letting this just kind of play out without any judicial guidance, and which is never a good thing. So we don't even know what she's going to do on the 22nd and beyond, because there's no, she's just not present in any of this.
Right. I don't see her being open to this at all, because I feel like it, if it can be interpreted as, she didn't do things right, or she didn't clarify, or she didn't do this, then she's not going to want to entertain.
No, but they're all going to realize, if they haven't already, that when this gets denied summarily, that the criticism factor is going to go through the roof. And moreover, I'm telling you, the idea that jurors, when they're told that this means nothing and nobody wants to hear any of this, I would have to believe that at least one, probably multiple, if not several, if not all, would say, I'm willing to be heard even without my name, because this is, and tell the world what happened, if for no other reason to clear their conscience out of fear. What if she ends up getting convicted when we voted to acquit her? I mean, I can't imagine being a juror and having that on my conscience.
Yeah. I agree. I know people are asking me to read through it. I was trying to get all of my questions in, like, I know you're limited on time, so I can read it, but I wanted to get all of my stuff in. So whatever you have to go, I don't know what time you have to go, but I'm going to read through it until I'm going to hold you hostage until you tell me that you have to go. Okay, so now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene after causing death, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. That part is it's like it's kind of like coming out swinging.
Yeah.
The legally inappropriate reliance as to the substance of
Yeah.
jury
No, it's
deliberations.
very aggressive, and none of this has any value. And if we haven't said so already, it's your fault anyway for being too dumb to object. I mean, that's what they're saying.
Yeah, yeah. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court. Well, first of all, let's stop right there. Given a full opportunity to be heard. But not when they said mistrial, right? Like when.
No, but what they're saying, no, I agree with you. But what they're saying is that you slept on your rights, and at some point, you should have stood up and said, well, wait a minute. We want to talk before you do this. But the other thing is, and again, Massachusetts is a unique place. In the real world, what happens when you get a jury note, like what would have happened, I can only use my own experience in New York. The judge would have called the parties back without the jury and said, we have a note. Here's the note. And this would have been we're hopelessly deadlocked, da, 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 da. And the judge would look at the parties and say, does anybody want to comment on this or have anything that I should hear from either of you in terms of what to say to the judge?
Yeah.
Now, I don't think that happened here. I think she just got the note and said, you're out of here.
Yeah.
And according to, the latest affirmation of Jackson, the jury didn't know that was coming and was kind of shell shocked. And it's like, wait a minute. We meant to do this and it was too late. So, but the DA's position is, what's for dinner?
Right.
Care.
Yeah. Yeah. Okay, so the jury's communications to the court explicitly indicated an impasse on all charges. I don't know that I agree with that. The communication to the court, obviously we don't know what was said to the judge.
They're taking liberties with their interpretation about, what the actual note was. And, I think the parties could argue by interpreting what it is, and they're just advocating for what their view is. I mean, I don't know that I necessarily agree with it either, but that doesn't offend me because there was a plural in there. And obviously their whole point is that this is nonsense.
Yeah. Okay, let's see. The court carefully considered alternatives before declaring a mistrial. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. Has there ever been a time when they've
I've never seen
it?
I've never seen jurors within 48 hours unrelated to each other, if you accept what the lawyers are saying, contact multiple defense lawyers and say, this is a miscarriage of justice. This is not what we did. And then, of course, because these people have no self-awareness, when they say unsubstantiated but sensational, that's a dig at Jackson and Yannetti, obviously. Like, you guys are chicken littling the process and trying to stir the pot with nothing. That's just, a dig at them more than anything.
Yeah. All right, let's see. Defendant was indicted by Norfolk for second-degree murder, manslaughter. I'm skipping through some of that stuff. Okay. Leaving the scene of personal injury and death in violation of the code. April 16th, 10-week jury trial commenced. Gosh, it felt longer than that.
Didn't
it? It was like the trial that never ended. Jury began deliberations on the 25th. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence. So the lesser included, I wonder if they were held up on that. I wonder if any of that was if they were all, the ones who were guilty for that one, if they were guilty on just the main one or some of the lessers, or, I would love to know
Yeah, well, as you said earlier, that may very well be why they said we're hung up on the charges. And the DA's position is, kind of like the three monkeys, see no evil, speak no evil, hear no, like, we don't want to even know, where it's possible that the jury could say that's what the question was about, and you never gave us a chance. And then you just said, I'm declaring a mistrial. And the next thing you know, we're just kind of looking around like, what happened?
Right.
And
Right.
the DA's position is we don't have any interest in hearing whether that was the case or not.
Yeah. Which is wild to me. That's wild to me.
Yeah, no, they're more interested in their position of winning and preventing this than doing what's necessarily or possibly right.
Yeah.
They have no concern that there is the possibility that an acquitted woman could be retried for the same crime.
Yeah.
They won't even acknowledge that that's a possibility, even though it's quite clearly a possibility that warrants some further vetting and fleshing out of evidence to determine, and it may have no merit, but it doesn't hurt to hear it out.
Yeah. Especially given how many eyes are on them right now for all of the things that they have done wrong, and all of you would think that like this would be your chance to say, you know what, we care about justice. Let's, there could be nothing to this, but let's at least make sure that we're, doing it when everybody's watching them. It just seems like it could.
Don't care about their credibility. You can shoot them. They're just going to rise from the dead and keep walking to you. You can't humiliate them by saying value your credibility, be honest, pursue justice, wear the white hat. They don't care.
Yeah. Yeah. Let's see. So the defendant's motion states that the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Yet the defendant's motion and supporting affidavits of counsel gosh, I cannot talk. My mouth is so dry and I didn't get water before I sat down. Inexplicably omit the full. You know what I feel like reading this with a dry mouth? Remember when Trooper Paul couldn't say definitively, and he was like definitely. Anyway, that's what I feel like right now with no water. So inexplicably omit the full opportunity that the defendant was given to be heard and the defendant's consent to the mistrial. So the thing about it being sudden, brief, and unexpected, it was sudden, brief, and unexpected to me in that moment. Not that she declared the mistrial, but that there was no... When she said that, she's like, I'm not going to do this. I'm going to, whatever. I had kind of anticipated there being some kind of discussion between them, even if it's like outside the presence of the jury, like talk to the, attorneys after that or something. But
so two things at play. Number one, as I said, the judge doesn't discuss the note with the lawyers beforehand and say, what are we doing? She just takes the note, reads it. And then number two is, Massachusetts basically has this procedure that if they come back at an impasse after they get what they call this Tui Rodriguez charge, that unless the jury expressly says we want to go back to work, that the court has to declare a mistrial. Now, the lawyers may know that, and that may also make them sit quietly. But more importantly, the jury doesn't know that. They may not know that the judge is not going to talk to them and clarify things. And at least that's the interpretation I got from that one affirmation yesterday from juror D or 4 or whatever, which was she just declared a mistrial. And we're all looking around like, what the hell just happened?
Yeah. Because the instruction was not clear at all, because it says, I think the way that it was worded, it said something about, when y'all are able to come to unanimous decision, then you check the box, or whatever. But if there's no unanimous decision on one of them that's right smack dab in the middle,
right. And the jury is, at least according to the affirmations in front of the court now, appears to have a very logical basis for being confused, and at least through the lawyers, it's being explained. And the position of the DA is, so what?
Yeah.
Didn't jump up and down and say, is there a verdict on any charge? So we don't care.
Yeah. Yeah. Let's see. Beginning on Friday, June 28th at approximately 12:15, the jury sent a note. I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. At that time, the court requested argument from the Commonwealth and defendant as to whether the jury had engaged in due and thorough deliberations. The Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations.
So this is meaningless to me. It doesn't matter what happened the first time. Okay.
Right.
Critical issue here is what led to the mistrial being declared. The fact that they were sent to go back to work and that the defense had previously said, no, give them the charge. It's clear they can't deliberate.
Right.
That's has no bearing on the ultimate issue, which is, did they reach a verdict? I mean, in this situation, they were sent back to deliberate. And
right.
those deliberations at that point would be controlled by that Bluford versus Arkansas that they cite, which is whatever the jury said, if the court orders them back, what the Supreme Court is saying is people could change their mind. So you don't know. Now, at that point, they didn't say they had a verdict on anything. But
right.
The difference, again, is that when they came out the second time, they did not go back and deliberate. And according to the jury, or some of them, they weren't allowed to explain, well, wait a minute, we did reach a verdict. But that Bluford case doesn't apply. It's not on point because that was their final argument.
Yeah.
Not argument, deliberation. They did not go redeliberate. And every single juror, at least as is being reported by two lawyers, making, by the way, sworn statements, okay? They could be criminally prosecuted if they're lying. They're not lying. You may think the jury is crazy, that it's not reliable. Jackson and Yannetti are not lying. They're telling you what they were told, okay?
Yeah.
And what they're being told is that 12 out of 12 jurors did not understand what was happening. This is not the verdict or not the outcome that we thought we were getting. And I think it's also very important. It's also different than that other case that was discussed in the DA's response, that juvenile case from 1984. In that case, they wanted the jurors to be hauled back. I think it was 6 months later. That's a long time. Okay. Yeah. In this case, they called within 24 hours saying, this is not what we did. Yeah. That should be alarming to anyone who has any sense of justice. Doesn't mean they're right. It doesn't mean the verdict or the non-verdict gets replaced. But to be so dismissive of the fact that, the defendant that you've been dedicating the last 3 years to trying to do everything to get her convicted for anything may have in fact been acquitted on 2 of 3 counts, to not allow that to at least play itself out. Some kind of fact finding. Again, I mean, I'm repeating myself, but it tells you what you're dealing with. These are not model prosecutors. This is not what they should be doing. Doesn't
do
mean
you feel like do you feel like this part was added in there? Because he goes through Yannetti saying, everything that he said about the word exhaustive is the word I think is operative here. I feel like he's adding this part in to make it look like, look, Yannetti wanted this, which is kind of, like saying like, oh, almost like trying to add in fluff. Like,
yes.
He can't do it now. He's, it's kind of like it's defeating. Because I agree with you. Like, this stuff has no impact. Like, this is not the thing. Like saying that they've exhausted because they can't come to a decision is under the assumption that it's on all of the charges.
Right. And also what he's describing here in these papers is the first time they sent the note.
The Tui Rodriguez,
and just like the jury, according to the Supreme Court, could change their mind strategically, so could the defense.
Right.
What Yannetti argued the first time has no bearing on whether they ultimately waive their right or not to consent to or not consent to a mistrial. So I find that to just be,
fluff.
That's exactly what I couldn't get the word out. And that's exactly
all right, let's see where else. I'm not going to read that whole thing that
I have 10 minutes by
the quote. Okay. Let's see. So on Monday, July 21st. The jury sent another note. So this is, and she did, and this was the thing, is like she read it in front of all of them together. Despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. Okay, so following the receipt of that note, the court again inquired of the Commonwealth and defendant as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for approximately 22 hours, given the length of the trial and the number of witnesses, the jury had yet to engage in thorough deliberations. Unetti again sought a Tui Rodriguez. So again, that's just going back through the same stuff. That's like the fluff, like trying to make it like, look, Unetti wanted this, but it's a totally different.
I agree. And I don't read the note as to say that it means that we are deadlocked or not deadlocked on everything.
Mm-hmm.
What I read it to say is that they're not in agreement, for sure.
Right.
Of course, there was a hung jury on something, which means by definition, they're not in agreement. So,
right. Because I think that's one of the hard parts of this too, because I can understand for a jury who, they're not watching trials on YouTube during the day, and they're not attorneys, and they're not, so if you have a verdict slip that you don't turn in until everything's unanimous, all you're thinking is you can't turn this in because it's not all unanimous. Like we can't,
right.
We haven't reached a verdict because our verdict slip includes 3 different things. So we're not supposed to turn it in as a verdict until we've agreed on all 3 of those things. So I can see why that would be, confusing to them.
Yeah. And the problem, I think, also is that the jury is not aware that when they send a note, a second deadlock note that simply says what their note says, that under the law of that state, that's it. You're going home. And had they known that, now, you're not going to tell them that because you don't want to influence their deliberation. But the point is, by not knowing that, if they had known that, they might have said, we have a partial thing. We need to know, what does it all mean? And the reality is the judge just said, I'm declaring a mistrial at that point. I mean, there was no, but I also think critically, she didn't really, other than just say, what are we doing here? She read the charge. Okay. She gave them the charge and they come back and say, we're deadlocked. Okay. Then she just says, I'm declaring a mistrial. There was no further discussion with the lawyers. What do we do now?
Yeah.
Just,
yeah. Yeah. Or clarification on, which, I mean, I don't know that I would have thought to clarify on.
Well, there's an interesting point here in page 4, which I find interesting, which I don't know that is necessarily going to help the DA. Not that, again, the judge is not going to do what they want him to do. But her comment that I've never seen a note like this, if anything, might have warranted discussion about what is her thought process. What are you talking about? What are you worried about? You've been trying cases or sitting over cases for 20, 30 years, and you're saying you've never seen a note like this. What does that even mean?
Yeah.
I mean, might that make her a more relevant witness? I would say so.
Yeah. Yeah. That's a good point. I didn't even think about that. Let's see. So the final note, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Continue to find ourselves. I'm trying to think of it, like anything in the note that could, I don't know. I'm dissecting it more now than I did the first time. Perspectives on the evidence are starkly divided. So some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Following the receipt of that note, the court discharged the jury and declared a mistrial. Representations made in counsel's affidavits have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise.
Right.
Um,
And now they cite the case I'm talking about, the Massachusetts one from 1984, which was floating around the other day. And again, in that case, they wanted to bring jurors back, I think 6 months later, because they found on the floor of the jury room jury slips that they checked off not guilty, but they were never filed. And the court said, we're not doing that. You know, how do we know it was final? The difference here is this is not literally speculative. It is hearsay, but
yeah.
it's not like we have to know what the jurors are going to say. You're being told what the jurors are saying, and you're being told it's 12 out of 12. And I think it's really critical from a credibility standpoint that not only are you apparently being told that this is 12 out of 12 jurors, but a good portion of those were willing to convict her of something. So these are
Hmm.
not necessarily people who are attempting to just throw this in the tank and some kind of scam to, some kind of sketchy way to like have regret.
Hmm.
Um, Clearly, they thought about this and have, a view that possibly something happened here, but we're quite certain there was no murder and no leaving the scene causing an injury. So,
Yeah. And I think that, think about how much time they spent on that. I feel like if you spend that much time and, we saw the reports that some of the jurors, like there was a juror that was crying and that some of them seemed kind of emotional when all this was going on. I mean, they spent a lot of time on this, hearing all this evidence and going through this. So I can imagine that, and the emotions involved in the deliberations. So I can see why it would be important for them to have their voices heard on at least what they could agree on.
right. Yeah. And I mean, sometimes repeating yourself is worth it because the point bears repeating. But think about what's going to happen here. These jurors think they acquitted someone of murder.
Yeah.
They see a DA is basically saying, we don't care what they think they did. You didn't tell anyone, too bad for you. And her lawyers didn't do it the right way, too bad for them. And then probably they're going to see a judge who says, too bad for everyone. And all that's going to do is invite these jurors to say that I need to get this off my chest and tell someone, because I'm not taking this to my grave that, I could have, by not clarifying, and I want my voice to be heard. And even though I feel terrible that we didn't check the slip or do it the right way, I do want people to know what our position was and that publicly we acquitted her. And then
Yeah.
whatever happens after that, shame on all of you.
Yeah. Yeah. Mm. I And if any jurors want to talk to me, I will listen. I'm curious to hear.
Probably going to happen at some point. I mean, I think when this gets denied, I think it'll happen.
Yeah.
Or, they see the news articles that come out today where the DA says we don't really care. I mean, that could lead to it as well.
Yeah. Oh, Amy's Positive Pathway says, does Rule 27 apply to this?
Yeah, I mean, there's that whole thing about partial verdicts and, the court may do it, but then there's something in the comments to that rule that talks about that if there is a partial verdict, it must be published. But the question here is we don't know, because the DA's position is no, there's no partial verdict because they never literally told anyone. It appears
Right.
that the jury wants to be heard to say, practically speaking, there was, we just didn't know how to convey that. So I think this is confusing and that doesn't resolve anything. I mean, look, to me, it comes down to fundamental fairness and just doing the right thing and letting this get fleshed out. And then you can make a legal decision. But how do you not want to hear, as the judge and DA, at least hear what happened? Because what if something happened that shouldn't have happened and somebody gets retried for murder? That should never happen.
Yeah. Yeah. And I know, again, repeating, if it does go to trial again, they need to drop the murder charge. I don't think that there's any chance of that going through on any jury. C. Tennessee versus Swift, verdict for how Bev could have handled. Tennessee versus Swift. Oh, I'll have to look that one up.
That's not what I think it is it? Isn't she from Tennessee?
Oh yeah. Oh, her.
Her, yeah. She's a big one in our house, let me tell you.
Oh, really?
Oh, yeah. I'll tell you a real quick funny story before I go. But last October, I knew a guy who's very big in movies, just big, and so we were invited to go to LA to the Taylor Swift movie premiere at the Grove in LA.
Yeah.
And so my daughter is like the world's, she's an 8-year-old girl, so you know what that means.
Yeah.
I mean, her whole life revolves around Taylor Swift. So we actually sat in the theater at the Grove where, it was like theater one, the good one. And she came right in there and was talking to people. And that was like a dad moment for life, right? I mean,
Aw.
she's like 20 feet away. And yeah, now my son didn't have much interest in the movie, but,
Yeah.
but they did get to, see Taylor Swift from 20 feet away. So,
Aw. That's
yeah.
cute. That's like, that's like childhood highlight stuff.
Oh my God.
Meeting your idol.
Oh my God. Just obsessed, like beyond belief. But
Aw.
that's not unique either, as you see every little girl running around. But
Yeah.
Yeah.
Cute.
Anyway. Yeah.
Okay, so this is a lot of this is the stuff that you were talking about, the case law that they were talking about
Yep.
with the stuff. So hearsay comments and juror statements about what happened are legally irrelevant as the jury failed to reach any verdicts.
You're
This
a
is all
juror.
the
How do you feel about that? And they're saying, but we did, and nobody wants to hear what we have to say.
yeah. I mean, that would be especially, with all the times and emotions invested in. I have a feeling that, like you said, like this response being so like, nope, don't want to hear it, and kind of aggressive, it might, especially on the ones who were, not guilty down the board. I feel
Right.
like, those, especially, it would make me.
Yeah, I mean that's a really good point. I mean, there are at least I don't remember the exact count, but there appear to be 6 jurors or so who are not guilty across the board. They are going to be pissed off completely.
Yeah.
Sure. And again, nobody wants to hear what they have to say, and whether they're right or wrong. The law is a law. I get it. Lawyers make arguments, but the perception they're going to get is the DA doesn't care, the judge doesn't care, nobody cares but the defense and the public. So I'm going to talk to them, and that's what's going to happen.
Yeah. Intolerant says came in late. TV heard from the 5th juror. Yeah, we talked about that, about the foreman, four-person.
So I have to run off for now.
All right. Thank you so much for jumping on here with me. I know it's last minute. I messaged you. I was like, hey, you got a minute? Let's break this down. I was like,
I mean, this is going to keep happening. I mean,
yeah.
Look for more affirmations probably in the next couple days, because they're going to try to pile it on now.
Yeah, so. I keep trying to take a vacation, and it every or at least just a day off. I just need a day off. It doesn't happen.
Stream from the beach, or that's not practical.
Oh yeah, I wish. I wish if I had enough Wi-Fi out there, maybe from my phone, but then I can't.
Yeah. No, I
can't. But
all right.
I will. All right. Thank you so much. I appreciate it.
You well. Okay. Bye.
Bye. Love him. Thank you so much to him for getting on and giving some of the legal stuff, because I needed to know. I needed to know the legal stuff. All right, I'll finish going through this, finish reading this, and then I'm going to, I keep saying I'm going to take my day's shot now, but that's okay. But we'll finish reading through this. A 5th juror came out. Yeah, the 5th juror was the 4-person apparently. Now, this is not another legal filing that has come out. This is, from what I keep hearing, it's an interview that was done by Turtle Boy, where he was saying that he confirmed. Tell me if I'm wrong, because I have not read it. This is just what's been sent to me all day. That he confirmed that it was unanimous on counts 1 and 3. And he was actually one of the guilty votes for the count 2, I think is what I remember. Wild Child, hello, happy anniversary. Yeah, oh, Good to see you too. I know I've missed y'all too. I have needed a break after this though. I say a break. I have not had a break at all. I've been working more than I normally work, but it's all been on podcast stuff because there's a bunch of big stuff happening. So, but I have missed streaming. I will be back. I will be back soon. Mark has been so awesome making himself available to talk with everyone. Yeah, he has. He was great. I love the, you know, we call it 13 jurors here because we talk about all of this as like, you know, with layperson looking at evidence and talking about it. But I do appreciate when I have attorneys come on and give us their thoughts on it too. Let's see. I follow this prime world, live in Massachusetts. If I was on that jury based on those instructions, I would have assumed to not mark anything unless he came to a conclusion at all of them. That is the way that it sounds when you read it. Yeah. So I can see why that would be. And I mean, that's not something like you turn in like, okay, we're ready with our verdict, but we still got these other things to discuss. It is told to them when they, you know, come to a unanimous decision on them. So I get it. Nikki, thank you. Kelly Reed was in here and asked if you could share her story. Oh yes, I saw Kelly earlier. Asked if you could share her. I cannot read or talk today. Asked if you could share her store for popcorn sale for Karen Reed Defense Fund. Yeah, send me the link and or send it to one of the mods. I don't know if I have. I don't think mods can post links, right? Send it to one of the mods and you can post it. That's fine. Is she still in here? I saw her earlier and then I started reading. I can't watch chat when I'm reading, so I don't try to ignore y'all. I'm just trying to make as much time as I can with Mark while he's here. Let's see. Oh, I can take these off now because I don't have to hear anything else. Look, I got headphone marks from having them on. It's okay. Let's see. Oops. Thank you so much, Michelle. I listened to your podcast this morning. You're an amazing. Thank you so much. It has been a labor of love. I think I finished that episode at like 2 o'clock this morning and loaded it and then got a few hours of sleep. Hi. Hi, Kelly. If you send the link to one of the mods, then yes, they can post it for you. I don't know. Or if you can send it to me on something, but I'll probably miss it because I'm reading this. So if you can send it to one of the mods, we can post it. Not a problem. And how is she doing, by the way? I can imagine this would be stressful. Even when I'm always busy with stuff, but I like to get on for a minute and see what y'all have to say and look at stuff. Thank you so much. Thank you so much. I appreciate it. I appreciate it. Okay. I think I caught up on chat now. I'm going to read. So if I miss something, if you need my attention, if you tag me, I will probably see it more. But when I'm reading, I don't always see everything because it's hard for me to read stuff and see chat. But we'll finish reading through this real quick. So This is going through the case law. United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the four-persons report was not a final verdict, because the jury had continued to deliberate and, more importantly, gave no indication that they were still unanimous on the murder charge. So this is going over some of the case law stuff that they're citing on why it should not matter, which, again, to me is wild. See, now I see y'all tagging me. Hi, Ricky Watson. Hello, hello. I miss y'all too. I will be back. I've just been working on other stuff. Make your own pop-up popcorn so we can all buy from you. Well, buy from Kelly. She'll do it. I can't make anything else right now. I am so... My plate is so full. My plate is so full. Oh, yeah, good idea. Send the Facebook link. We can put it in there, too. Good idea. Good idea. Okay, back to reading. Sorry. Didn't take my ADD medication today because I wasn't planning on working. And yet I've been working all day. A single juror's changed of mind, blah, blah, blah. Okay, so that was all the... This is all the case law. I want to skip through the case law and just get to what they're saying about... Because Mark just kind of broke down the case law. All right, so... The jury's notes were unambiguous that the jurors were deeply divided by fundamental differences in our opinions and state of mind. That resulted in a starkly divided jury as to the charges, emphasis on plural. So this is what we were talking about with there being the emphasis on the plural. The one that they are not unanimous on, according to these affidavits and everything, is the second count, which has multiple charges. So having this... say like the emphasis on the multiple charges, it doesn't really, I think it doesn't, it just doesn't hold a lot of weight with me, because there are multiple charges that they were having to decide on for the second count. So to me, that could be read as that too. The jury consistently indicated that their impasse was not due to a lack of understanding the law or the charges, but a profound divergence in deeply held convictions, ultimately leading to a point where consensus is unattainable. So it says that their impasse was not due to lack of understanding of the law or charges. So, but again, lack of understanding of the law or charges is not the same as lack of understanding for how the verdict slip works, or how to go forward if you don't have a unanimous decision on all of them, since that's how the instructions were worded. Ultimately leading to a point where consistency. Okay, so the jury's notes did not indicate agreement or acquittal on any of the charges. Rather, it was evident that the jury was unable to agree on any charges due to their sincere adherence to the individual principles and moral convictions. Contrary to representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial, as she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. So again, this is one of those things where so they're wanting her, they said that she should have objected when the judge was like, all right, mistrial. I would think that if they're saying, you know, that that they haven't decided on it. I like I said at the beginning of the stream, I know some of y'all came in late. If it were me and I'm, you know, that I'm not going to see that I'm not going to automatically assume, I bet they agreed on one. Because again, jurors don't know, you know, not all jurors necessarily know. And there's not a lot of those that we see. We don't see a lot of trials where they, you know, convict on some and not on, and then acquit on others. Or not acquit, hung jury on others. Most of them, you know, we've seen some, I can't remember which one it was I mentioned this one before. There was, he was convicted on, I think they got him on the gun charges, but they couldn't agree on the murder charge or something like that. But that's the only one recently that I can think of. So he was acquitted on that, but he was convicted on the gun charges. I don't know if y'all remember, you can say it, but So I wouldn't think that the when they're saying, oh, she should have objected when the judge called a mistrial, I don't think that that would be what's going through her head. Is it? I bet they were, how are you going to object to that? Charge two was, it wasn't a DUI. It was actually a vehicular manslaughter while operating the vehicle under the influence. So, and then it had lesser charges included. So if it's basically like there was no intent, but she did, get drunk and hit him with a car, basically. But that there was no intent on it. That it wasn't like she was like, you know what? I'm mad about Aruba. Screw Laura Sullivan. Or screw Marietta Sullivan. She sucks. Let me hit him. Still the stupidest motive I've ever heard in my life. But what do I know? Did they take blood from her or just a breathalyzer? Well, state police didn't do any. The only blood that they have, or I say state police can't police nobody. No police. The only, they did an extrapolation to get the range on what they believed her blood alcohol level to be. So, but even that is not, there's no, even with the extrapolation that they did based on that, because it was, her blood was not collected from state police, or I keep saying state police because they're the ones who ended up taking over, since it was not collected from law enforcement. The state police lab that did the guy that did the extrapolation, he can't even, he had on his report that this does not fall under our accreditation. He can't even count it under their accreditation because they're not the ones that took it. I have never done jury duty. They would never have me for jury duty. They would never. It was the only charge that was specifically included liquor, which apparently was a sticking point for some jurors. That doesn't surprise me. And we talked about that in here, that might be one of those things that people get hung up on. To me, if the car didn't hit, you must have quit. But what do I know? Hi, Chrissy Bacon. Thank you for not starting your vacation yet. I keep trying. I've been trying to go on vacation for a week and a half now. It's not happening. Bribera, thank you. Remember 2 months. 2 months seems like just last week I started watching. See? Time flies. Time flies. The team is staying whole. Attorneys, family, friends, until Karen is read. So this is one of the rumors that I keep hearing, is that Jackson's not coming back, and that she's going to replace Jackson and Little and keep Yannetti and somebody else. I keep hearing that rumor, and so I'm glad you're clearing that up, because when he said something about, in whatever he released, that was something about the I think it wasn't, maybe it was a response to the stuff happening with Proctor, and it was something about like, we can't wait for this or whatever, and I was like even that shows that he's still in on this, and he ain't got no quit. Let's see, I'm trying to catch up on what some of y'all are saying. Stupid Proctor. Stupid Proctor. Okay. I saw people that were feeling sorry for him for losing his job. Well, suspended without pay until further investigation, but basically losing his job. I saw people that felt sorry for him. I was like, like that, why would you feel sorry for him? I don't get it. Why would you feel sorry for him? You wouldn't feel sorry for him if he had done this investigating one of your family members. I don't get it. I don't get it. All right, so contrary to the representations made in the defendant's motion and supporting affidavits. Oh, she had out. Okay, I read that part, which removes any double jeopardy. What else? I'm trying to skip through the case law because I really was not planning on going live today, but I want to get what they said out since I had Mark on. He went through case law stuff. So if you're joined us late, you can watch what he said when we're done. Okay, so during her full opportunities to be heard on June 28th, 2024 and July 1st, at no time did any of the defendant's 3 counsels request inquiry as to what charge or charges the jury was deadlocked on. But okay, think about the trials that we've had before. Can anybody, or any trials that you've watched, can anybody think about when they've had jurors come back and say that they can't agree? Can you think of anybody that, like any of the defense attorneys or prosecutors that were like, you need to find out exactly which one? I've heard the judge, specify and clear stuff up. Jackson and Little are 1,000,000% staying. See, you heard it here, folks. You can tell people they can stop with the rumors. Can this get to higher courts quickly? I don't know. No, I wish it would have. When did the defense have a chance to do anything? She said mistrial and jury dismissed. Yeah, they're saying that they should have objected to saying mistrial. Because that was the thing, is that second note or third note or whatever it was. The note after the Tui Rodriguez, the one on the mistrial, she didn't discuss it with counsel first. I never did get water, no. I was trying to make it through. Suffering through for y'all. All right, so let's see. Rather, the defendant was quick to request a Tui Rodriguez. Okay, so this is back to the Tui Rodriguez one. Let's see. We went over that one with Mark. I'm trying to make sure I read anything that we didn't go over with Mark so we can finish it. That's more case law. That was the case law. All right, so the court engaged in considerable efforts and sent the jury back to deliberate 2 times following the notes that they were at an impasse, in addition to finding that the jury had engaged in due and thorough deliberations and providing the Tui Rodriguez instruction. Again, all of this stuff doesn't really matter. Like all of that stuff, it really just doesn't even matter, because that's not what the case, like giving them more time has nothing to do with what they're saying and what happened, it, like, this is all to me just doesn't matter. It doesn't matter. Brainy, just so you know, Karen watches these shows. I can't imagine what it would be like to sit here and have to go through all this and then to think you're going to have to go through it again. I can't imagine. I have zero empathy for him and the fact that the union tried using the kids and their health insurance as a way to gaslight people. Just discussing. These are plenty of people struggling right now. Yeah, Proctor, I don't feel sorry for him. I don't feel sorry for him. They have added a new attorney to the team, but nobody is leaving. Yes, we saw that. They had, I can't remember the name because I didn't take my ADD medication, but I know chat will know it. They're better with names than I am. Unless I have a spreadsheet. She didn't even read the day note until the jury was in the room. I think that's the biggest deal. And if she's going to do that, that's fine. But I think that it should be discussed with the attorneys after that, because like they did with the, she discussed the other ones with them, but she didn't on this one, which was, it's crazy to me. That's a good question. That's a very good question. How many trials other than Mass versus Reed, how many trials has Judge Canoni picked juror number 1 for the 4-person? That's a really good question. Because I would love to know that that's just how it is. But with the way that this case has gone and this investigation has gone and this prosecutor has gone, I just don't trust anybody anymore. I really don't. Not in this case. That's a really good question. Don't give me any more rabbit holes. I don't have time for any more rabbit holes. But I would like to know. In some places, juror number 1 is automatically the head of the class. Yeah, see, in some it is. And like that's what Mark was saying, that's how it is in New York where he tries cases, but in some of them it's not. So I would love to know if that is the law there. And if it's not, how many times she's chosen number 1. We'll see. I would like clarification regarding the selection of the jury 4-person before the alternates were selected. That seemed sus to me. Yeah. Yeah, what if number 1 was picked as an alternate? No more rabbit holes. I'm so busy. All right, let's get this wrapped up so I can get some water and start my vacation. It's never going to start. Let's see. Tui Rodriguez. That's case law. I think most of this we already went over. I was trying to make sure we read anything that we didn't get to read when Mark was with us. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. We went over this part. I think we've gone over most of it. I think that's pretty much it. Went over that. Went over that it was, they say it's improper for the court to inquire. That was case law. Yeah, so I think we've been over all of it now. So for the foregoing reasons, the defendant's motion should be denied as there was no verdict that acquits the defendant, no grounds for the court or counsel to inquire into the deliberative process of a discharged jury. The defendant consented to mistrial and the court consented to mistrial is interesting. Okay. Due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherence to individual principles and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the 3 indictments and any appropriate lesser included offenses. So, there you go. Also, I talked to Dr. Kinsey this morning. Oh, and I need to change the time on that. Let me add it to my list of crap I got to do. I need to change the time on that because we're going to push it back a little bit later. But on Tuesday, Dr. Kinsey's going to join with me. Okay, and I recommend. I talked to him a little bit about some of what he thought And y'all need to be there for that one. Y'all need to be there for that one. I'm not gonna give some of his stuff away. Y'all need to be there for that one. So he's going to go over the crash reconstruction stuff, the evidence, the I mean all that stuff. Like, so I've got a list of stuff I'm getting together that of questions. And if y'all have any questions that you want to ask too, you can send them to me, or don't send them to me. My box is flood. Mods, maybe somebody can start a thread in the Facebook group or on Twitter or something. If you send it to me, it will get. I don't send. I need an assistant, and Lucy doesn't do anything but sleep all day. She's sleeping now. So the questions that you have for him, if we could start a thread and get those, then that way I can compile them through the thread. But I recommend you be there for that. He was talking to me a little bit about some of his experience, and how this is not as uncommon as it should be. You know, the prosecution trying to make stuff work and stuff like that. I think it was really interesting. And I love hearing his opinions on the evidence. Remember when I had him on the podcast episode, and he said one of his things that he was saying is, you know, he has the prosecution is going to have to find a way to explain those arm injuries, or else they're going to have a really hard time, because he said that, you know, he's never seen plastic taillight lens do that to an arm, or to, you know, that kind of damage to skin. And he said if they're going to put that on the car, if they're going to say it's from the car, then they're going to have to find something underneath the car. And of course, you know, they didn't. There was no evidence of anything underneath the car. So they went with taillight, and taillight doesn't work. So I think that was really, he's got a lot of, I can't wait for y'all to hear what all he has to say. And he has so much knowledge and experience on crash reconstruction stuff that, you know, I have so much respect for his opinion, and I can't wait for y'all to hear what he has to say. I can't wait. Mildred, thank you for the super chat. Thank you for delaying your vacation for us. It'll come. One day. Oh, I'm going to push it back to 5. What time did I have it at? 5:30. So we're gonna do 6:30. Let me add that to my list. I need to change that. It'll be at 6:30 Eastern on Tuesday. So make sure you were there for that. Do you really think Karen did it? She would have tried saving his life, knowing if it was saved, he'd probably tell them it was her. You know, there's so many things that, like, even like, you know, hollering at him on voicemails and calling 53 times, and like, there's so many things that just, and calling right after she left, you know, like, she was mad. You don't call 53 times if you know somebody's, you know, if you know that you just hit somebody or killed them or whatever. You don't call 53 times for that. You call 53 times because you're pissed because they're not answering, and you want them to come home. So yeah, it'll be 6:30 now. I gotta change it. Oh, too much. There's too much that is There's too much wrong. And I don't know if y'all have listened to, if you haven't listened to the episode, the last couple episodes of the podcast have been my absolute favorite because I feel like these are like the finally putting together like some of the expert stuff. The one that I finished this morning, I put it out at like 2:00 this morning or something. It's the first half of Trooper Paul's testimony. And then the second half will be released next week. And it's got like the stuff with the crash daddies in there and stuff. But it is when the way that I break everything down, I don't just go through and then summarize what they say. The way that I break everything down is I download transcripts and I copy and paste and put everything in different categories. Like, you know, they may talk about this at one time, you know, on direct examination here, and then talk about it, you know, on cross-examination here, and then have, you know, whatever. I take everything that has been discussed about any one topic and put it all together. And when you do that with Trooper Paul's testimony, it shows how all over the place it was. And with some of the ones that I've done that with, it, like with Jen McCabe, perfect example, putting all of her statements and all of her testimony together shows how all over the place it was. And Trooper Paul is one of those where when you take all of the stuff and all of the questioning and you put it together, and then for each of those topics, I have layered in what the crash daddy said about it. So as you're going through, and most of that's in next week's episode, as you're going through, every time Trooper Paul says what he thinks happened and gives his calculations, well, he said he didn't really do calculations because it was a side swipe. Whenever you go through and hear, this is my favorite episode I've ever done. When you go through and you hear what he says happened and how he came to that conclusion, and then immediately after that you hear crash daddies explaining so clearly why it can't be that. When you hear it like that, it is incredibly powerful. I can't wait for y'all to hear it. Normally I'm putting these episodes out, I'm like, oh my God, I'm so tired, just get it out. I am so excited for y'all to hear this one. I spent more time on this episode than I have any other one too. But it was the most important. This is what everything has come down to. This is what everything has come down to. Did that car hit that man? Period. That is what everything has come down to. So I put a lot more time into this one than any other because it's the most important, and it is my favorite episode. I cringed so hard hearing him stumble over his big statement of the accident again. Dude forgot his memorization of it. So let me tell you something funny about this. There are, in some of the episodes that I do, when I do clips from court, I will cut out like the ums and the, you know, whatever, if they're just kind of taking up time, because I know that podcast listeners are finicky, you know, and sometimes don't want to hear that. So I will take some of that out. But if there's a lot of it and I feel like it has a kind of gives a little bit of insight into how, okay, like for example, exactly what I did. I stopped and I said, and I was trying to find words. When that happens, when you're on the stand, I feel like it's because the answer is not coming naturally. You're having to think about what to say. And on some of these, when he's talking about how he came to a conclusion, it should not be that. There should not be questions. You should not have to try to find the right answer or how to explain something when it's something that should be based on evidence, logic, and science. And when he answers things, he stumbles on his words some. He seems very nervous to give his answers. And he is, I'm trying not to be like disparaging, but like he's not confident about it. And also it just sounds almost like forced, like he's almost like he's not embarrassed to say it, I guess is the wrong word. I don't know. It seems almost like he just can't, he can't even believe it himself that he's saying this. And then you compare that to the crash daddies who give you such a clear explanation on why something could or could not happen. And it is solely based on science. And I broke down, because they mention all these different sciences and they talk about what they are, but then they never really go into it. So I broke down each of the sciences that they mention and exactly what part they apply to, and that part's really interesting to show you the basic knowledge and understanding of what he has for the sciences that should be applied to crash reconstruction to come up with these theories, and they're not. I think one of the important things to remember too, that's interesting, he has been given the lowdown or whatever he called it, and told that this was a pedestrian collision and she was going backwards. He was told that. The crash reconstructionist was told that. But that's what the state police said. And I feel like if you are going to be given the job of figuring out what happened, it should not be based on what somebody else is telling you. I don't, I feel like that should be his job. He shouldn't be. And that's why I think it was so interesting that that the round, what was it, the round thing in a square hole or whatever, I can't, the words escape me, but it's like trying to, like, you're given what you need to be true and told to make it be true. And I feel like that's the big difference with him and the crash daddies. He is given evidence and told, tell us, like, give us a way that we can explain how this happened. In stark contrast to that, they are told to decide, to determine if it's possible that this happened. And that's two very different things, because he's trying to make something work and they are trying to see if it does or not, or if it could or not. And I think that's why this is so interesting and so important, because it's just two very different ways to go about the different possibilities of this. And it's I can't wait for y'all to hear it. I can't wait for you to hear Dr. Kinsey too, and to hear what he says about it. Get in the car. Yeah. Thank you for super chat. Bev started taking new dates for trial as soon as she said you're through to, yeah. Yeah. She was ready to move on. Square peg and round hole. Thank you. Unmedicated brandy. Unmedicated brandy. Can't get words in my ADD brain. All right, let's see. I think I have. Do I have? Yep, here it is. I have the link. Kelly sent me the link. Why is it not letting me click on there? Let me see. Oh, it won't let me post it in here. It says the link is too long. Now let me try it. There we go. That should be it, Kelly. Did it work? Did it work? I think so. I think so. Yeah, it worked. I just checked it. Okay, the link is in comments now. Link is in comments. Appreciate y'all popping in today, even though I was late. Yeah, I appreciate y'all popping in. I appreciate Mark. I knew that I wanted to hear the attorney perspective on this because I read it and I was like, they're coming out swinging, coming out aggressive. And it seemed like it felt so, God, I need water. It seemed like it felt so dismissive. And to me, in this moment, that feels very tone deaf. So I wanted to hear an attorney's perspective on it. So I messaged him, was like, hey, got a minute? So I appreciate him coming on. Broken Baker, you jinxed me. I told you that as soon as you said vacay, something would happen. I literally said I'm taking today off, and then every time. But that's okay. I am taking tomorrow off though, and I'm turning off notifications on my phone. Well, I'm taking most of tomorrow off. I'll be on Broken Baker tomorrow night. Oh, Broken Baker has a 10K stream tomorrow night. And I'm going to get on there. So y'all make sure hop over there. Hop over there. All right. I specifically asked for no bombshells until Monday. The audacity. With this case, it's never ending, but really take some time for yourself. You've been working super hard and we really appreciate it. Thank you so much. Thank you. I put God, you have no idea how many hours. I put a lot into this because it is something that I truly believe in. And I've said this from the beginning that I am going into this with all of like with my mind open. The things that my mind is, closed off to is that I had seen that, there were problems right from the get with either the investigation or the witnesses or both. But I wanted to go into this and stay open and really weigh the evidence. And I feel like the more I dug in, the more I was like, this is really messed up. Whether or not, even like before we get to the evidence that could come out about whether or not she, could be guilty or not guilty or innocent or anything like that, just the stuff that was so screwed up, I feel like really needed to be talked about, highlighted. I know that, Turtle Boy is very aggressive. That's his style. And that style doesn't work for everybody. So the thing that worried me is that I'm like, I feel like there are so many people who aren't going to hear this because, the main spokesperson for it is like, I mean, it's effective. Yeah, it's effective. Everybody knows who he is. His style is effective. You can love him. You can hate him. You can be somewhere in between, but his style is effective. What worried me is that I didn't want people to completely shut out the things that he was saying that are true and that need attention on them because they don't like his style, or because they assume that because they don't like him that anything he says is not true. And I didn't, like, I've not watched a lot of his coverage, and I've said this before, like I wanted to come to my own opinions. So I had watched a few things in the beginning to see what different people were saying, but then I stopped watching everybody else's coverage. I wanted to get an idea of why people were divided. And then I stopped, and everything that I did, I dug into myself and did all of my own research. And then I would get, like some of the stuff I would find, and I'd be like, oh my gosh. And then, people would be like, oh yeah, we've found that out, like, 3 weeks ago or whatever. I was like, oh, okay, well, but that shows I'm not stealing anybody else's research. But, and then there were some things that, like I know he said there were some things that I had said in the podcast, I guess when he listened, that he didn't hear. But my big thing was I wanted everybody to be able to see these problems. These are big problems. This is stuff that needs attention. And I didn't want people who didn't like him or like that kind of coverage or that kind of stuff to immediately dismiss it because of their feelings there. And some people still do. Some people hate him, so they'll disagree with everything you say, and that's fine. Not everybody can separate emotion from that. But I have put a lot of time and effort into this because it is something that I truly, truly, truly believe in. Like that there needs to be changes. And I'm glad to see that there have been changes coming. I'm glad to see that, Proctor is a big one. Like that's a big one. And this is something that may be slow to change, obviously, but at least it's, it's coming. So I am tired. I am so tired, but I'm happy. I believe in this. So, but also need a nap. All right. I'm going to jump off here. I really need water. I really need to try to salvage some of my day, and I've still got work to do. I'm going to change the time on the thumbnail and the stream that's set for Tuesday. But I recommend hit notify me on there, because I recommend everybody needs to be there for that one. I cannot wait for y'all to hear, Dr. Kinsey and what he has to say. And I love hearing people who I genuinely respect their opinion. I love hearing, their input on things. So I would love for y'all to hear. I can't wait for you to hear what he has to say. So, Mermaid says, you and Aiden have different styles, but he has said he gives kudos for your work. That's the thing, is like, everybody's going to have different styles. I think that, could you see me? Could y'all picture me like being aggressive like him? No, because it's not who I am. Could you see him being like me? Like, no, because it's not who he is. We're two very different people. But that's the thing about something when it really matters, is that you can have two very different people who are looking into it themselves and doing it their own ways and have their own styles, and still see that there's a problem. And, if it's a problem to somebody you hate, it can still be a problem to somebody that, you don't. I feel like people let emotions with him get involved or get, cloud the way that they look at this stuff. And that drives me crazy. But it is, Proctor is the, hopefully, first of many big changes in that area. So we'll see. And we will keep the notifications coming for all the stuff that's going to come in the future. I keep having my post trial list of stuff that I'm going to go over on the podcast, and it keeps growing. It keeps growing. Can you portal us to RA? Yes, I can do that. I can do that. Let me get it set up real quick. And I am going to be on Broken Baker tomorrow evening, and then I am going to do potentially a short stream on Monday or Tuesday during the day. I'm not sure yet. To go over some of the other stuff, but it won't be a long one, but I'll put that in the community page when I figure out exactly what we're going to do. All right, portal. And I would have put something in there for this one, but I just kind of messaged him, was like, hey. So we literally just went live, and then that was it. All right, where is, oh, there's RA. Okay. All right, I'll portal y'all over to him. All right, y'all, I appreciate everybody. I will see y'all on whatever. If I see you tomorrow, I'll see you tomorrow. If not, I'll see y'all next week. But I appreciate everybody.